All rise, please.
Thank you. Please be seated. Good afternoon, everyone. We are going on the record on case CR 33-21-2230, State versus Pierre Lake. Mr. Lake is here, represented by Attorney Jim Archibald. Rob Wood represents the state for the Madison County Prosecutor's Office. This is the time scheduled for sentencing. Mr. Wood, is the state ready to proceed?
Yes, Your Honor.
Mr. Archibald, is the defense ready to proceed?
Yes, Your Honor.
Very well. Court's permitted media to attend this hearing. I've been instructing courtroom staff to advise the media of the parameters of what's to be broadcast or photographed in this case. So please adhere to those rules that we set down. The court at this time then will go through a brief procedural history of the case as we get started on sentencing here. I would note we have the court reporter present and are making a record, so keep that in mind, counsel, and anyone addressing the court today. So, Mr. Lake, at the time of your arraignment on November 8th, 2021, you were informed that an indictment had been filed against you by the state of Idaho, and in that indictment you were charged with 4 crimes. Count 1, murder in the first degree of Ralph Edward Bryan. Count 2, attempted murder in the first degree of Karen Chappell Bryan. Count 3, burglary. And count 4, felony grand theft. At the time of that arraignment, you were advised of the potential penalties involved with those charges, your constitutional rights, your plea options, and the consequences of exercising each of those options. You initially pled not guilty to the charges, and this matter was scheduled for trial. After extensive plea negotiations in this case and efforts through mediation with another district judge assisting with those efforts, eventually the parties reached a plea agreement in this case, and the court did receive and review the plea agreement, which was filed on October 19th of 2023. After the plea agreement was filed, then the court ordered a pre-sentence investigation report, or what we refer to as a PSI, and scheduled this matter for sentencing. The court would note the following terms are included in the plea agreement. The plea agreement indicated that you agreed to and did plead guilty to count 1, the count of murder in the first degree, count 2, the charge of attempted murder in the first degree. The state agreed it would dismiss the burglary charge in count 3 and the grand theft charge in count 4. And then the parties mutually agreed, and this is an important provision, through a binding provision in the plea agreement, that a sentencing recommendation would be made, including a fixed determinate sentence of 30 years of prison with an indeterminate life sentence. The remainder of the terms of sentencing were left to be free to be argued by the parties. And I want to make sure, given that this is a binding plea agreement, to confirm that with counsel. So, Mr. Wood, first of all, did I correctly cite the provisions of the plea agreement in effect today? And secondly, is the state still wanting to move forward under the binding terms of the plea agreement?
The answer to both those questions is yes, Your Honor.
All right, and just to also confirm on the record, Mr. Wood, I know this case involved a mediation, but I assume the victims in this case, or families of the victims, were notified of the agreement prior to it being submitted to the court. Is that correct?
Yes, they were, Your Honor.
Thank you. Mr. Archibald, has the court correctly recited the plea agreement?
Yes, Your Honor.
All right, and is the defense willing and ready to move under those terms of that plea agreement?
Yes.
All right, the court in this situation with the binding plea agreement has the discretion to accept or reject the plea agreement after I've reviewed the PSI in the case. The court did receive the PSI. It was filed January 22nd. I thoroughly reviewed the PSI, and upon consideration of the case, the terms of that plea agreement, and the recommendations made in the PSI, the court has concluded that it will accept the terms under the binding plea agreement at this time, including those provisions addressing the determined length of the prison sentence. So the court, having made that preliminary determination, now will move forward to the next stage of this proceeding, which involves consideration of evidence and recommendations. So going back to that PSI report then, I'll first inquire of the state. Mr. Wood, was the state able to review the PSI and all of its attachments?
Yes, we were.
Was there anything in the reports that you thought needed to be clarified or corrected?
No.
Mr. Archibald, have you and your client had an adequate opportunity to thoroughly review this pre-sentence investigation report?
Yes, Your Honor.
Is there anything in the report that you believe needs to be clarified or corrected?
Yes. Just a few items. On page 10 of the pre-sentence report, the calculation of the LSI score is 23. 23, as they correctly point out, is moderate. On page 19, the assessed potential for recidivism, the pre-sentence investigator then states that the defendant scored a 23 on the LSI, which is high risk. And so the high risk there needs I'm asking the court to cross out high and put in moderate, because the LSI score of 23 is a moderate.
All right, the court's reviewed that revision. I find it's appropriate. In fact, it is calculated as a 23 on page 10, level moderate. The table indicating what's moderate is included on page 19. 21 to 28 is moderate, so 23 is not high. The court therefore will amend on page 19 of the PSI in that second paragraph where it says high risk category will be amended to read moderate risk category. Mr. Archibald, any other clarifications or corrections?
Yes, on page 18, the pre-sentence investigator lists out my client's prior criminal history. The pre-sentence investigator then states the instant offenses are his second and third felony conviction. A juvenile felony charge is not a conviction. And so on page 18, where the pre-sentence investigator says this is his second and third felony convictions in this case, that's incorrect. Since a juvenile felony is not a conviction, I've asked to strike that language about second and third felony conviction. That's contained on page 18. And then also on page 20, the pre-sentence investigator makes the same statement that this is Mr. Lake's second and third felony convictions, which is incorrect.
All right, that's my understanding as well, Mr. Wood, that a juvenile conviction is not technically a criminal conviction. It's a violation of the Juvenile Correction Act, and while they grade those offenses, I would tend to agree it's probably a misnomer to call them a felony conviction, because under Idaho law, I don't think juvenile offenses serve as convictions. Do you have any response to that?
Your Honor, I don't know that we don't have an objection to that request. It doesn't change anything about the state's plea agreement. And we do have questions about the Montana conviction. And so we don't have an objection to that request.
All right, what I think I'll do, Mr. Archibald, to make it more accurate is to read the instant offenses are his second and third felony. Well, it could be changed to offenses because they were charged as juvenile offenses, but they aren't convictions. And the first criminal convictions would be correct. Any objection to me modifying convictions in the first part of that to say offenses?
No, I think that's correct. That if the word conviction is stricken to say either charges or offenses, as the court points out, that would correctly reflect the law.
All right, the court will modify the PSI on pages 18 and 20, interlineating instead of second and third felony convictions, it will be offenses. And so the court will do that through an delineation in the PSI that ends up part of the formal record of the case. Are there any other suggested clarifications or corrections?
No, Your Honor, thank you.
All right, the court then has reviewed the PSI, and I do intend to rely on that information for sentencing. Let me confirm at this point, before we go further forward, Mr. Lake, do you intend to stand by your plea of guilty in this case and proceed with sentencing at this time?
Yes, I do.
Very well. This time I'll next ask then and inquire about who may be presenting any statements here in court today. I'll note that included in the PSI are multiple victim impact statements, which I have reviewed and are part of the record. Victims also may have the right to make a statement in this sentencing hearing. Mr. Wood, are there going to be any victim impact statements presented today in court?
Yes, Your Honor. Karen Bryan will be making a statement.
Anyone else?
Amanda Westminster will be making a statement.
Amanda Grimmer. Oh,
Amanda Grimmer. Sorry, I said
Could you, for the court reporter, could you guess that last name again?
Grimmer.
All right. Any other statements, Mr. Wood?
Robert Ryan Rousbrother will also be making a statement. and Twyla Kent, Ralph's sister.
What was the last name?
Kent.
Okay. All right, let me inquire from the defense. Mr. Archibald, is anyone going to be making any statement today other than potentially replying?
Just me and my black.
All right, this time then I'll proceed with recommendations for sentencing, beginning with the state and Mr. Wood. After Mr. Wood has made statements, and I'll allow the victims to speak first, then Mr. Wood, you can make your recommendations. After that, Mr. Archibald, you can make your recommendations, and then finally Mr. Lake, if you would like to address the court directly, you can do that after your attorney. Mr. Wood, if you'd like to call up first impact statement of a victim, we'll put that on the record at this time.
Your Honor, we'll start with Karen Bryan. The state would request that while she makes her statement, if her children could stand by her for support.
I can do that, and we'll have her sit at council table there and talk into the microphone. I would admonish the media here that you're not permitted to show her. You can show the audio of what she's saying or later rebroadcast, because I'm not permitting live broadcasting, but in your footage, please don't include any photography, still, or video of any of the victims making impact statements, please. So.
Yes, Your Honor. Ralph Bryan was my beloved husband and sweetheart and best friend of almost 40 years it would have been. He was my business partner and financial dependence. We have 4 children, the very best. And I would add to that family, all of his family here behind us. Every birthday, anniversary, holiday, and special occasion will is only going to bring back a lot of things. I attend, anyway, I don't need to say that, but Your Honor, I just want to say much has been taken from this family. And it's been almost 2.5 years, but it feels just like yesterday. So. How life will be changed moving forward. I won't get to talk and laugh with the man that I love the most. I won't be able to go on trips with him to see my grandbabies. We won't be able to build our dream house and live in a long retirement together. Our traditional family get-togethers, camp trips, four-wheelers, rides, birthdays, and celebrations will always be missing the life of the party. And Ralph was definitely the life of the party, that's for sure. The one that loved everyone the most. I'm not sure what my future's going to look like, but I do have a good family around me, so I know that we're just going to be there for each other. He was my business partner, as I said, and sole provider. This had a wider impact than just me and my kids. There are so many close and dear friends, family members, business associates, and the community, I'd add. A lot of people knew Ralph. So many people are mourning the unnecessary loss of my husband. The love of my life was beloved by so many, and a community is forever changed by this experience.
Thank you for your statement. And please state your name on the record.
My name is Amanda Grimmer. I'm the oldest daughter of Ralph and Karen Bryan, and with the death of my father, life has changed dramatically. My father was an integral part of our day-to-day life, not as a financial support for us, but as a pillar of strength, love, reliability, and so much more. I'll never get to see my father again. I won't be able to laugh at his jokes or cry on his shoulder. I won't get to see him and hug him at all of our Sunday dinners and ask for his advice when I need it. He attended every first moment of my children's life, from their first steps to piano recitals, cheer events, gymnastic performances, basketball games, softball games, track meets, and orchestra concerts. My older kids will have memories and experiences of their grandpa, but my youngest children will never have that. My mom lost the love of her life. She now lives with us, me and my husband, which we're so grateful to still have her here with us. It's heartbreaking to watch her every day mourn the loss of her loved one. I'll never be able to watch my parents grow old together, and he'll be missed dearly at all of my children's and my siblings' future firsts. From their first high school dates to graduating from school and one day getting married. We'll always mourn the gaping hole left in our family from this giant of a man whose heart was always bigger than life itself and whose family was his center. My life and the life of my kids and my mother and siblings will forever be changed because of this senseless act. Moving forward is inevitable, but we're forever changed.
Thank you for your statement.
Thank you, Your Honor.
Please state your name on the record when you begin.
My name is Robert Bryan. Ralph was my brother. I am his brother. You know, we go through life making decisions. And there's really not much more I can say other than one. The family has let you know that this tragedy that's happened to us and our families affects a lot of people. I hope that you can one day find Father in heaven and search for forgiveness. Because one day I had to do that too. To forgive you for the act of violence, cruelty that you did to us and our family. And I hope someday you can find that, man. I do. With all my heart, I do, man. He's a great guy. It's sad to think he's not here anymore. There isn't a day go by that I don't miss him. You know, I'll pray for you, man. I will. Because you'll need the Lord's help to get through what you're going through. you can find that piece that you're gonna need for the day when you transfer to the other side, you need to be prepared. And that's all I have to say, Your Honor.
All right, thank you, Mr. Brady. Please state your name as you get started.
Well, it's Twyla Eileen Kent. I'm Ian's sister. I'm Rexburg's sister. My sister, who could not be here today, wanted me to ask you why. Why would you do something so cruel and so senseless? Would you do something like that to a family? And take my brother and brother from me. You took a husband, you took a father, you took a grandfather away from his family. Yes, it's so sweet. Do you understand that? You hurt a lot of people that day. I sat there and I walked into the emergency room and I sat and watched my brother's hand bleed profusely. But he was just never going to go away. I watched my sister-in-law struggle because of all the damage that she did to her arm by stabbing her. Do you even know? My brother said, I pray for you, I really do. Because one of these days, I hope that you wake up. You really truly realize what you've done and how you have affected this whole family sitting over here. Look at them. You have affected all of them. You have affected a community. Because why? Because you wanted to be something. We took away that day from us, a very solid stone in our foundation. And we had to really work hard to build that foundation back up. And as a family, we become stronger. And we will always be strong. But for you, I feel really sorry for because you will never, ever be able to experience the joy of holding that first baby. Or working a job and being proud of the work you do like my brother was. He was a good man. He was a hard worker, and he did a lot of good in this community. And you, sir, will never ever experience that because of your choices. That's all I have to say.
All right, Mr. Wood, at this time, if you'd like to offer the state's recommendations on sentencing, you can do that.
Thank you. Your Honor, the state would just begin by acknowledging the victims here. The statements they made, Karen and her children, Cody, Amanda, Wyatt, and Samantha, and Ralph's siblings and in-laws and friends who were here. Your Honor, I think this is the third time in about a year I've stood up in front of the court and asked the question, what is the value of a life? And the answer is that life is invaluable. And what does justice look like in a case like this? What is justice what is justice for a victim when they're murdered? And the reality is that nothing we do today will feel fair. And nothing we do today will feel like true justice, because nothing we do today will bring Ralph Bryan back. Nothing we do today will heal Karen's scars or the traumatic memories she has to live with every single day. Murder is so heinous because there is no way for the defendant to give back what he has taken. And murder literally tears at the fabric of society. All murder is horrible. This particular murder and attempted murder is so egregious because it was completely senseless. This defendant had no reason to attack Ralph and Karen. He didn't know them. They didn't know him. They never did anything to him. They never did a single thing that would warrant what he did to them. And yet he took Ralph's life and very nearly took Karen's life. And the court has seen the reports. These acts were brutal. I don't know that any of us can imagine the horror of that night for Karen Bryan. Not only the injuries and the violence that she suffered herself, but to experience losing her husband and life partner the way she did. This case is a community's worst nightmare. While the rest of our community's loss is nothing compared to Ralph, Karen, and their family, our entire community suffers from a crime like this. We should be safe in our own homes, and we shouldn't have to worry about a complete stranger breaking into our homes, harming us, and killing our loved ones. And this defendant has taken that security from this community. As stated earlier, the state and defendant did enter into a plea agreement, and the state will stand by that plea agreement. Where the defendant has pled guilty, this court must sentence him under Idaho Code 184004 to a life in prison, and that at a minimum be an indeterminate sentence. All first-degree murder requires that. As part of the plea agreement, along with the indeterminate life sentence, the state will recommend the defendant be eligible for parole only after a period of 30 years. The state would also ask for a $5,000 fine pursuant to Idaho Code 19-5307. Whereas murder is the ultimate crime, anytime the state enters into a plea agreement regarding a murder, we want the public to understand and the victims to understand exactly what the agreement is and what it means. Based on the joint recommendations of the state and the defense, a life sentence with a chance for parole at 30 years does not mean that the defendant automatically gets out at 30 years. He will have to earn the privilege of parole. With the seriousness and egregiousness of his crimes, he's going to have to prove to the parole board in 30 years that he deserves that. Even then, if he does make parole, should he engage in further criminal behavior, he will always have that life sentence looming over him. This defendant has a lot of learning to do to be eligible for parole. In his PSI, the state notes the defendant has surrounded himself with friends and associates who are involved in criminal activity. He claims to be a member of a gang and has had issues with his, as it says in the PSI, his gangster persona. Again, nothing we do today will bring Ralph back or take away the trauma that Karen has experienced or the trauma that their family and friends have experienced. Justice and the law, at a minimum, requires the indeterminate sentence of life in prison pursuant to the plea agreement. We ask that he not be eligible for parole until a period of 30 years has passed. Thank you.
All right, thanks for the recommendations, Mr. Wood. Mr. Archibald, at this time I'll allow the defense to make its recommendations, beginning with you.
Your Honor, I'm asking the court to go along with the plea agreement in this case. The plea agreement did take us a while to get there, as the court knows. And I want the court to know that certainly wasn't my client's fault. It's the first time I met him. He's been willing and able to take responsibility for this crime. primary reason. In this case, he kept getting bumped back. So for the Bryan family, I apologize for the delay. It certainly wasn't meant to torment you at all. So the first time I met my client, he's a scared 18-year-old kid, a teenager. And I'm just thinking to myself, how did you get here? How are you accused of such shocking, horrible facts? Because to me, again, he was just a nice, friendly teenage kid. He's always been good to me. He's been good to his family, his phone calls. He has absolutely no excuse and no justification for what happened here. He knows that all he's got caused here is sorrow and heartache. So when we consider a plea agreement, we take into account how do we deter Pierre and others from conduct like this? How do we rehabilitate him? How do we punish him? And how do we protect society? So I believe that this plea agreement takes into account all of those factors of sentencing. And that this 30 years to life to an 18-year-old kid is a long time. It's hard to conceive of what 30 years means to an 18-year-old. I think it's safe to say that's a long time. It's a long time for Pierre to be rehabilitated. It's a long time for him to be punished. And it's a long time to protect society from him. That if he's doing these kind of things at 18 years old, it's probably a good thing to keep him locked up for a while. Because I like him. I like my client. He's nice and friendly to me, respectful, never had an attitude with me. And so it just doesn't make sense. And I agree with Ralph Bryan's family that it just doesn't make sense. And sometimes we never really will know why. How did this happen? Why did it happen? And being in the criminal justice system for over 30 years myself, I can safely say we just never figure it out. We never really will know why. So it's my request, Your Honor, that this plea agreement be accepted by the court, that the plea agreement does take into account factors of sentencing as outlined by the Idaho Supreme Court. Thank you.
All right, thank you, Mr. Archibald. All right, Mr. Lake, before I impose sentence, if you'd like to address the court, you can. This is known as a right of allocution, which permits you to make a statement on your own behalf or present any information in mitigation of punishment you committed. Would you wish to make a statement at this time?
Yes, Your Honor.
Go ahead.
Well, first and foremost, Your Honor, I do understand. I'll never really understand what I did take that day. I hope I can get to a point where I do come close to understanding, and there is no excuse for what I did to your family. And I really do hope for one day come close to understanding as you have lost a father, a brother, a husband, a grandfather, and I'll never know how that feels, you know, like, and I want to say that I'm truly sorry for what I have done, and I do hope that while I'm locked up, that I can get the rehabilitation that I need to change my mindset. And, you know, this is, as my lawyer stated, and so is Mr. Wood, that this is the best thing. If I'm doing these things at 18 years old and younger, it's not a good thing, man. I do need help. I'm just sorry for everyone that's been affected in your family, and like his children's life, my children's lives. There's 7 kids now. When I grow up, never not having to know that their father did something like this, and they're not gonna. Like, and that hurts me. That hurts me. And like knowing that there's 4 kids on the that have now lost their father, that have those memories, that their kids will never get to experience those memories from. And I'll never be able to, you know, see my grandkid like for the first time. I'll never be able to see those first steps. And I know that I've taken that away from him as well, and his family. And I just want to say that, again, truly I'm sorry for what I've done. I hope one day that I can, after a certain amount of time, come out and be a productive member of society, and hopefully one day be someone that, you know, my kids can look at, not be completely disappointed. Thank you.
All right, thank you, Mr. Lake. Mr. Lake, are you fully satisfied with the representation you received from Mr. Archibald? All right. Mr. Archibald or Mr. Wood, is there any legal reason why the defendant should not be sentenced today?
No, Your Honor.
No, Your Honor.
All right, at this time then the court is going to pronounce sentence. Mr. Lake, based on your plea of guilty, it's the judgment of this court that you are guilty of count 1 is alleged in the indictment, murder in the first degree for the murder of Ralph Edward Bryan in violation of Idaho Code 18-4001 to 4003A. You are also guilty under count 2, based on your plea of guilty, of the attempted murder of Karen Chappell Bryan in violation of Idaho Code 18-4001, 4003, and 306. The court's reviewed the information contained in the pre-sentence investigation report, and I've fully considered the statements made today as well as the arguments of counsel, noting again that the parties entered into a binding plea agreement here, which the court has now accepted. I have reviewed your prior criminal history, which consists of those previous juvenile adjudications, which are not convictions, but there are counts in there of a criminal history that really, given the timing of those, it is concerning that you were just barely over 18 when this horrible felony happened. It's going to impact the rest of your life and has impacted so many others. Leading up to that, you had other previous juvenile issues, and the court won't go into those because those are juvenile records, but that's a concern. The pre-sentence investigation report ultimately does recommend incarceration. Clearly, it's a requirement under the statute that you're convicted of under Idaho law. There aren't really any other different recommendations in there as it relates to anything like substance abuse evaluations, a game score, mental health reviews, etc. Those weren't part of the report the court received. The court does, however, have to consider in addition the sentencing objectives, which, as defined in the State versus Two-Hill case, is narrowed down to 4 things there. Protection of society, which is the primary objective, the deterrence of the individual and the public generally, possibility of rehabilitation, punishment or retribution for wrongdoing. All of those factors weigh heavily in favor of an extended prison sentence given the nature of your crimes. In addition, the court has to consider the factors of Idaho Code 1925-21 on the question of whether or not the prison sentence that is agreed to in the plea agreement is appropriate. And I do want to walk through some of those factors given the nature of the crimes again in this sentence that will be imposed. So when you look at things that mitigate and weigh in favor of avoiding a prison sentence, under Part A, and this is from Idaho Code 1925-21-2, the defendant's criminal conduct neither cause nor threaten harm. That does not apply. The defendant did not contemplate the conduct would cause harm. That doesn't apply. The defendant's criminogenic needs indicate the defendant would benefit from supervision. That wouldn't apply. And there are other lists as it goes down. The only factor in mitigation I find looking at the list in that statute would be under Part J, which is the defendant demonstrates amenability to treatment. And I would find that would be a mitigating factor here, given the young age of the defendant when this occurred, and generally, I think, the significant time spent incarcerated already, that I don't believe there's any indication that Mr. Lake would not be amenable to treatment to address the criminogenic needs. Looking then at the statute of what weighs in favor of a prison sentence, under Part 3A, there's an undue risk that during a period, if you didn't have a prison sentence, you would commit another crime or be harmful to another person. I do find that risk exists. That a lesser sentence would depreciate the seriousness of the defendant's crime. And that very heavily weighs here for an extended prison sentence, because looking back at those other factors, the court has to do what it can to send a message to you and to others that a murder and an attempted murder will always result in an extended prison sentence, if not a life sentence. The next factor, that imprisonment will provide appropriate punishment and deterrent to the individual. That does apply here. And a deterrent to other persons in the community, yes, that applies as well. What's not included in those factors is that you're a multiple offender or professional criminal, as the statute states. You're not, however, as I mentioned, you were already building a criminal history, and then at 18 years old, you committed this murder and this attempted murder. So the court also has to balance out the aggravating and mitigating factors here. And it is mitigating, and it's always been troubling to me that you were just so young when this happened, barely 2 months past your 18th birthday. And it's just so shocking and tragic that you threw your whole life away and took the life of an innocent person and attempted to take another life, and you were just barely old enough to even be in our adult criminal system when that happened. As Mr. Wood mentioned, we have a right to be safe and secure in our homes, and the way that you did this does strike right at the fabric of the community, and it just, I can't believe this happened in my jurisdiction here in Madison County. We have a home invasion where you kill someone trying to defend their home and their wife, and try to kill Karen with a knife. I just cannot understand the level of violence that would lead you to even do that. I don't think anyone will ever understand it. Everyone said no one knows why. You know why, because you did it. I don't know if anybody will ever get an explanation, but we're beyond all that now. You did it, And this sentence, there's never really been an explanation about why this happened, which is very troubling. Some crimes, you can kind of understand what took place. This just seems like a completely random, senseless act of violence that should have never occurred. And to be honest, I've really struggled with this plea agreement, and I have talked extensively to Mr. Archibald and Mr. Wood, and I have extensive experience working with both of them and trust in their legal judgment and opinions. And there are reasons the parties reached this agreement through mediation, and I do defer and have confidence in Mr. Wood in particular in his office in prosecuting cases. And so I do accept the plea agreement and will impose the sentence that's been agreed on. But again, I absolutely agree that it doesn't feel like justice, and nothing would feel like justice based on what you did to these people and this whole family here. So Mr. Archibald's done a good job in representing you, and there's only so much the court can do at this point because the damage you inflicted is done and can never be reversed. So on the count sentence, the judgment of this court that you will be sentenced to the Idaho Department of Corrections as follows: for a fixed minimum term on count 1 of 30 years of incarceration, followed by an indeterminate term of life in prison for a total unified sentence of life. On count 2, for the attempted murder in first degree of Karen Chappell Bryan, you're sentenced to a fixed minimum term of 30 years of prison, followed by an indeterminate term of life in prison for a total unified sentence of life. Those are to run concurrent. You will be given credit for the time served, which, as has been mentioned, is extensive. We've counted 860 days you've been in jail, and that gets credited towards your sentence pursuant to statute. The court's going to impose a fine on count 1 in the amount of $5,000 as a fine. On count 2, the court will impose a fine in the amount of $5,000 as well. Court costs are assessed on each count. The court will assess an additional civil penalty under Idaho Code 1953-07, which is $5,000 for the murder of Ralph Bryan pursuant to that statute. Mr. Wood, is there any additional restitution sought at this time in the case?
No, Your Honor.
All right, no additional restitution sought by the state will not be ordered. And finally, the court will assess, I'm going to waive actually any reimbursement for public defender services given the length of the prison sentence imposed here. So that will conclude the judgment of the court in terms of the sentence on each count. Mr. Wood, do you have any questions about the court sentence or anything I need to clarify?
Yes, Your Honor. On count 2, did the court say 30 to life?
I did.
Can Mr. Archibald and I approach?
Okay, I want to check and make sure on the statutory provisions on that to make sure it's correct. So let's approach and discuss that.
All rise, please.
Thank you. Please be seated. Okay, we're back on the record on CR 33-21-2230. In this case, the court just had a sidebar with counsel discussing the court's sentence on count 2. With counsel reviewed the statutory provisions, which are somewhat complicated because it's a crime involving a maximum of life, but it's an attempt, and then that directs to another statute, and then in addition there's a enhancement for the weapons enhancement under Idaho Code 1925-20, and having considered that, the court is going to modify the sentence imposed on count 2, which I indicated was a 30-year determinate term followed by an indeterminate term of life. And the courts concluded that the maximum possible that can be imposed, given that it's an attempt with the enhancement, is 15 years for the attempted murder under Idaho Code 183061, with an additional 15-year extension under Idaho Code 192520. So the court will amend its judgment on count 2 to a fixed minimum term of 30 years, and that will be followed by an indeterminate term that is 0, so a total term of 30 years, and that will still be concurrent with the sentence imposed under count 1 on the murder charge. So that will be amended to a 30-year fixed term as well. Mr. Wood, was there anything else you wanted to clarify or correct before I asked Mr. Archibald?
Yes, just quickly, Your Honor, I had said earlier, there was no other restitution the state had to ask for. I would ask for 30 days in case Crime Victims Services has a claim they need to make. So if we could have that 30 days, and we would notify the court and counsel in that time if there was such a claim.
All right. Is there any objection to a 30-day time frame to submit proposed restitution, Mr. Archibald?
No objection.
Very well. The court will permit the state 30 days to seek a request for restitution. If the parties stipulate or agree to that, the court may enter an order without a hearing. If the defense believes it's not reasonable and requires a hearing, contact us and we'll schedule that. All right, Mr. Archibald, do you have any questions or anything to clarify or correct on the court sentence?
No, thank you.
All right, Mr. Lake, any questions from you?
No.
All right, to conclude, counsel, then I would ask if you would please submit any written copies of the pre-sentence investigation reports. The court will destroy those additional copies to keep that information confidential. Mr. Archibald, did you wish to maintain yours?
I guess I do have one question. Did the court state credit for time served?
I did. I think it was 820 days. 860. All right, we've made the calculation, and what I indicated on the record will be credited on time served. 860 days served is where we're at for today. All right, if you would please submit your written copies of those. Mr. Lake, let me just advise you, you do have the right to seek under Idaho Criminal Rule 35. If you believe the sentence is in error or unduly harsh, you would only have 120 days to file that. You also may seek an appeal of this judgment within 42 days, and you may have rights under Idaho's Post-Conviction Relief Act. And Mr. Archibald can further advise you if you think any of those post-conviction claims would apply to your case. Ladies and gentlemen that have attended today, thank you for your consideration in the way you've conducted yourselves in this hearing. And unless there's anything further, that will conclude the sentencing, and the court will be in recess. All right, we're in recess. Thank you.
All right, please.